on the state's power to tax overstretched limits, 2-9-judge bench judgment by Honorable Sri Justice Rohinton Fali Nariman, sir, former Judge, Supreme Court of India. Now I invite our Honorable President Sri Endeavour of LiveLaw to adorn the chair of the dais. I request our executive member Ganapati and Srikanth to felicitate Honorable President by giving a bouquet. Now I invite Honorable Sri Justice Rohinton Fali Nariman, sir, former Judge, Supreme Court of India, to adorn the chair of the dais. I request our Vice President and Treasurer, Sri Deepthi Ma'am, and Shravya and Executive Member Sabina to felicitate our honorable guest by presenting a bouquet. May I now request our Honorable President, sir, to introduce our honorable guest today.
Honorable judges, senior advocates, Advocate General, Additional Advocate General, Additional Solicitor General, Public Prosecutor, Senior Designated Counsels, Government Leaders, Assistant Government Leaders, Senior Members of our distinguished guests and friends. On behalf of Telangana High Court Advocates Association, I heartily welcome you, sir, to our association for the lecture. Honorable Justice Rohinton Fali Nariman needs no introduction. Sir, born on 13/8/1956 in Poli, Sam Nariman, a distinguished jurist and Babsi of Nariman. Sir married Sanya Nariman. Rohinton Nariman had school education at Calcutta School, Mumbai, and college education at Sri Ram College of Commerce, Delhi. Then Sir had obtained law degree from Delhi University. Then joined Harvard and obtained master's. Sir had enrolled in the year 1979, was member Bar Council of India, designated as senior counsel when he was 37 years old. To make him senior designate, the rule was amended by then Chief Justice of India. Later, Rohinton Nariman was the Solicitor General of India. He worked since 27 July 2011 to 4 February 2013 and thereafter resigned. Subsequently,
the third, where two 9-judge bench judgments directly impact the nation in the economic sense. Now, these two 9-judge bench judgments have both undone two 7-judge bench judgments. The first is in the area of the mineral wealth of the country, which is Mineral Area Development Authority versus Steel Authority. And the second is in the area of industrial alcohol, which is again vital for the nation's economy. And that is called State of UP versus Bhatta Prasad Vaish. To begin with the first, that is the mineral case, it is important to realize that our constitution did not begin on a clean slate. A large part of it is taken from the Government of India Act of 1935. And in particular, Article 246, read with the 7th schedule, is almost directly borrowed verbatim from the Government of India, Section 200 and the second 97th schedule there. The 7th schedule consists of 3 lists. And when we talk of the 7th schedule, we are talking now of legislation. So you are talking of central legislation versus legislation by the states. Central legislation is covered by list 1. There is exclusive legislation given to the center, provided it belongs to a subject matter falling in an entry in list 1. Likewise, the same thing is done by the states in list 2. And then there is a concurrent list, which is list 3, where both the center and the states have concurrent jurisdiction over the subjects mentioned there. Today's lecture doesn't concern itself with the concurrent list at all. It deals only with list 1 and list 2. The principle of federal supremacy, which was accepted by the majority, is laid down in Article 246. Because 246 clearly states that where there is an irreconcilable conflict between an entry in list 2 and an entry in list 1 or list 3, is the concurrent list, the entry in list 2 must give way. And this is referred to as the federal supremacy principle. Second, you have in each of list 1 and list 2, but not in the third list, general entries dealing with general topics of legislation, followed by taxation entries, properly so called. The taxation entries cannot be read into general entries as a result. And the same obtains for the state list or list 2. Now for the mineral case, we are directly concerned with 4 entries which you must keep in mind at all times. Entry 18, first of all, in the state list, which says land, that is to say, rights in or over land. Then entry 23, which carves something out of land, because otherwise it definitely belongs to land. That is what is in the subsoil, the mineral wealth of the nation. So it says, mineral regulation and development, subject to, now this is very important, an entry in the central list, which is entry 54. Now this subject to is almost like a double federal supremacy principle. Because here there is no question of any clash between 2 entries. Here the moment under entry 54 list 1, the center thinks that in the public interest, it is necessary to take over the entire or part of the legislative field dealing with mines and mineral development. The state legislature has nothing to do with it once it is taken. So, the legislative entry 23 gets robbed of its content if under 54 there is a parliamentary declaration which says that in the nation's interest, we wish to take over mines and mineral development. So far, so good. Now in 1957, the Mines and Minerals Regulation and Development Act was enacted by Parliament. And that act very clearly enunciated by way of a declaration that we are proceeding to take over the entire field relatable to minerals and mineral development. It made the requisite declaration, followed by the sections, and in particular section 18, which showed that there was nothing left now for the states to legislate upon insofar as mines and minerals are concerned. And this was in fact so held by a trilogy of cases. Mind you, the Act divided minerals into major and minor minerals. And it also gave jurisdiction to the states over minor minerals. But it's only because the center did so that they get that jurisdiction. Otherwise they get none. So we had a famous trilogy, first in 1961, followed in 64, and then followed in 1970. So we have the first case, and so in fact the first two cases come from Orissa. And both are coal cases, so to speak. The first is Inke Ramco Coal Company versus the state of Orissa, followed by state of Orissa versus Tulloch and Company. The facts were almost identical. There was an Orissa cess that was levied on mining, which was recovered at the pit's mouth. And the question was as to first whether it was a tax or it was a fee. Currently pause for a moment. A tax and a fee differ in vital respects, even though there was a bit of a blurring in between. But there are at least two vital respects in which they differ. A tax is a compulsory exemption which you have to pay, dependent upon the activity that is carried out. It could be the earning of income, it could be the production of goods, it could be the sale of goods. The moment such a sale takes place, production takes place, income, the tax becomes leviable without more. In the case of a fee, on the other hand, there should be some special benefit that is given to the class of persons who pay the fee. Otherwise, you can't characterize it as a fee. And what is collected should not be too much more than what is defrayed by your expenditure for the benefit of those people. Now, the fundamental distinction, constitutionally speaking, between a tax and a fee is that taxes are clearly demarcated, as I told you. In the latter part of the two lists, this one and two. Fees, however, are attached to general and not taxation entries. So that you find as entry 96 in list 1 and 66 in list 2, fees relatable to matters that are laid down in this list, and likewise in this case. The question that the trilogy of cases was concerned with were fee cases, because ultimately they all held that the cess was not a tax, it was a fee. The second case in particular said that after the Mines and Minerals Regulation and Development Act of 57 had come in, the entire field where mines and minerals has now been taken over by Parliament. Nothing is left to the states. The last judgment by Ijnath Kedia, which was in 1970, was a case from Bihar. And there the Bihar Land Reforms Act added a second proviso, which purported to deal with minor minerals. The court struck it down and said that whatever can be done with minor minerals, you have to follow the drill of the NMRPA and you can't go outside. One very important argument was made by Lalda and Sinha in that case. And the argument was that in any case this is part of a land reforms act. So the relevant entry will be entry 18 and not entry 23. You remember entry 18, land, versus 23, minerals. This was turned down, saying, no, it may have something to do with land generally, but specifically only with minerals. Since therefore it deals with something specific that is minerals, you cannot characterize it as something being legislated under entry 18. This is important from our point of view. Now you come to the taxation entries in the state list. So we have general entries, an abstraction of the fee, and all fees therefore being leviable only by the sector. When you come to tax, you have entries 49 and 50. And they follow closely the general entries. Because 49 says taxes on lands and buildings. It's important that it is on, not in respect of. And 50, which is a peculiar entry, because it's only one of two taxation entries which is subject to limitations laid down by Parliament. Otherwise, the states have plenary jurisdiction to tax under this rule. And entry 50 says taxes on mineral rights, whatever that expression means, we'll come to it in a minute, subject to limitations laid down by Parliament by law relating to mineral wealth. Now, with this in front of us, we have now another trilogy of cases which tell us what taxes on land and buildings mean. And there we have three judgments, one in 69, one in 70, followed by one in 71. One dealing with the Wealth Tax Act, one dealing with the Urban Land Tax Act, and one dealing with the Gift Tax Act. Each of them, there were arguments that were made, and ultimately the court found that entry 49, which speaks of tax on lands, is in essence a tax that has to be directly on land as a unit, which means it cannot indirectly relate to land. It has to be on land and acreage, and land as a unit. So it's a property as against person. After these three cases laid this down, the width of entry 49 became clear to all. Now, entry 50, there was nothing direct except a dissenting judgment of Justice Rohinton the first of the first three cases. He gave down. And then Justice Rohinton said that a tax on mineral rights in any case cannot ever be on the activity of money. It cannot be relatable to royalty, for example, which is paid only when you actually mine. It is for the right to mine, for nothing more. Now this is how it stood until a judgment called HRS Murthy versus the collector in 1964 put a spanner in these rules. But then the question was, there was a cess on land and annual rental value was defined as including royalty from mining and therefore calculable on royalty. Question was whether it was in substance a land tax or a tax on units. And Justice Rajgopal Iyengar, speaking for 5 learned judges, held that it was a tax on land and said that in one pithy sentence, it was more directly connected with land than with minerals, although remotely with minerals. The exact opposite, if you remember, of what was said in Vaishnav area, but a few years later, because area was a later judgment in 1970. Now, with these difficulties before us, a 7-judge bench was convened in India Cement case. And in India Cement, again, you had a section 115 of another Madras Act. In the 1964 case, this case, you had a Madras District Court Act. Here, this was another Madras Act, which purported to define land revenue now as including royalty. Same thing. And this time, India Cement went through trilogy number 1, trilogy number 2, and ultimately said that, look, this thing about Murthy saying that it is indirect way minerals and direct way lands is absolutely wrong. It is in fact the exact opposite. And therefore, Murthy got overruled. However, in the process of overruling Murthy, the court also went into whether royalty itself was a tax. According to me, it was unnecessary. But they went into it because if it was a tax, then section 9 of the MMRP Act lays down limits. And then according to the court, therefore, those limits would apply because of 50, if you remember, said tax on mineral rights were subject to limitation by Parliament. Very finally, they quoted from two different points of view of the High Court and said, yes, royalty itself is a tax. Therefore, in any case, there are limits. And neither under 1849 nor under 1850 can you purport to touch minerals, because minerals are a special subject carved out of land. Now, this was accepted by Parliament. This is important to remember. India's civil judgment was delivered in 1989. Parliament came out with the Cess and Other Minerals Validation Act of 1991. And in that act, what it did was to save the legislation made by 7 states. So it said in a schedule, all their levies will now be treated as parliamentary levies. So it's very important therefore to remember this. Now this position continued and we thought that everything was settled now once and for all, in accordance with the scheme laid down by the Constituent Assembly. However, in 2004, in the state of West Bengal versus Kesoram industry, you had a 5-judge bench now. Don't forget India's bench was 7. A larger bench state always binds a smaller bench. The judgment in Kesoram found that according to it, there was a typographical error in the 7-judge bench. What was meant was not that royalty was a tax, but cess on royalty was a tax. And therefore they said, this typographical error, we will therefore interfere with the ratio of this judgment. Had the typographical error not been there, the whole judgment would have been different, which is incorrect by the way, completely incorrect. And they finally upset in a combination of 5 what was said by 7. And they went back to the Murthy position, saying that all taxes which are based on cesses based on royalty can be justified either as land taxes under 49 or as taxes on mineral rights under 50. Now, one very important thing to remember is, even assuming there was a typographical error, first and foremost, that becomes an error apparent on the face of the record, which you can correct only by review. That was never done, and the review would have had to be before 7 learned judges. So, according to me, the entire exercise in Kesoram's case ought to have been ignored. And it should have been said that this does not lay down a binding precedent at all, because it could not have undone what 7 learned judges did. Even otherwise, assuming royalty not to be a tax now, it certainly could not have undone the other ratio, which was a separate binding ratio, which said that when there is a cess on royalty, it has reference to something special mining and not something general land. And therefore it must go. Now, because of Kesoram, certain states again started raising their heads and started taxing the mineral wealth of the country, like the good old days, or the bad old days, as they may be. And these matters then came to a head and were referred to now 9 learned judges. which is now how you have the 9 learned bench judgment of 2024 delivered by the learned Chief Justice. The only silver lining I might tell you in both the judgments is that Justice Nagaratna dissented. And her dissent is forceful and logically plainly correct. So what did Mineral Area Development Authority now do? Mineral Area Development Authority relooks at the entire thing, the entire conspectus of provisions I have just shown, cases that I have just shown, and then says that no, a tax on mineral rights cannot be construed in a narrow pedantic fashion. Mineral rights means everything to do with the mineral. In short, you almost made it a tax in respect of minerals. Rights was ignored, on was ignored. Two vital words in entry 50. And they said every tax that can possibly be conceived of from the time that the mineral comes out of the mine till the time it is ultimately consumed falls within this entry in any case. Secondly, there are no limitations laid down by Parliament because royalty is not a tax. We will for the time being forget about royalty, whether royalty is or is not a tax. Doesn't according to me make the slightest difference. So entry 50 then became one area within which you could house this. But the court went on further, it didn't stop there. It then went on to say, and here it wrongly relied upon two earlier judgments. One was a judgment reported in 1975, Anand Mills, this is the state of Gujarat. And the second was an earlier judgment in Ajoya Kumar Mukherjee's case. Now in Anand Mills, there was an Ahmedabad electricity company that had laid underground electric lines. And property tax was demanded from them on the footing that they were occupiers of that land. Ultimately, the court said land includes everything over and under land. It's obvious, of course it does. And then said, therefore, you must pay that property tax. Now, this was brought in by the 9 learned judges to say that since everything under land belongs to land, minerals being under the land are also part of that. Forgetting completely the scheme of the Constitution, which is taxation quae both also followed the general entries, because the moment you ask yourself a question, what is a tax on land? You have to understand what land is first. And to understand what land is, you have to go to entry 18, which is the general entry. The court, however, divorced the two and said, no, the general entries have nothing to do with the taxation entries. Then, however, it went on to say, following the Goodrick group, which was a T group of cases, dealing with T dispatches, that Ajoya Kumar Mukherjee's case, which was the second case, dealt with markets and therefore dealt with land being put to a particular user. Now, if you put land to a particular user, you can use that user as a measure of taxation. And therefore, they said, if you use royalty as a measure of taxation for land, then there is a nexus between that user, which is for mining activity, and land, which makes it a land tax. The first problem with this is that land is immovable property. We can't ever forget that once a mineral is removed from the land, it is no longer part of the land. It is movable property. It is goods. So if you seek to confuse a movable property tax with an immovable property tax, then you are right, but you cannot do so, first. Second, they forgot that taxes are taxes directly on land as a unit. Now take a case where there are 3 adjacent lands. Each of them have coal strains under them, the same coal strain. In fact, they've been carved into 3 separate, let's say, units with 3 different owners. Now, the first owner doesn't mine at all. So he's paying dead rent. Assume the dead rent is 100 rupees for the year. The value of the land then becomes a percentage of 100 rupees. Assume that the second land now is owned by somebody else, and that somebody else is utilizing this particular coal and is mining it and pays, let us say, a royalty of 1,000. The percentage of royalty then on 1,000 will become 10 times that of dead rent. And the very land, therefore, which is next to the land on next to it, let's say plot A, plot B, plot C. Plot B today will be valued at, let's say, 1,000 and plot A at 100. Plot C, where the person is exporting and has to fulfill an export contract, is actually mining 1,00,000 tons. So immediately his land then becomes most valuable, and the percentage of 1,00,000 or whatever it is now becomes the value of land. That can never be. Because obviously when something is to reflect the value of land as a unit, that something has to be the same. The same land cannot, depending on mining activity, either become worth 10 rupees in a particular year or become 1,00,000 rupees. Same thing. In, let's say, the second year, for some reason, the 1,00,000 man becomes a 10 rupee man and pays dead rent. Can we say the property price has now become zero? So quite obviously, in my respectful statement, I would think that the link that is between royalty and land is snapped by two things. One, the fact that it is movable as opposed to immovable. And second, that it does not reflect the value of land at all. Now, with this, Justice Nagaratna has a very vigorous dissent. First and foremost, she defends her father's judgment, AR 72 Mysore, with all the vigor of a very faithful daughter, saying that a tax, that royalty is definitely a tax. And she spends, let us say, 70% of her time saying that royalty is a tax. And that from that it followed that Section 9 of the MMRD Act in any case is something which interdicts the states from going beyond what you can fix as royalty under Section 9. Then she tackles the other things. And she says, quite correctly, that when you have a general entry and a specific entry, as I told you, land and minerals, obviously minerals are carved out of land. They may generally, in some other context, be part of land. Yes. But in this constitutional scheme, they are obviously not part of land, because land you cannot touch, Parliament cannot touch. It's a plenary subject matter for legislation by the states. You remember, you have the Urban Land Ceiling Act, for example. Now even urban land is part of land. Parliament couldn't touch it. Parliament could only enact by virtue of Article 252, the Urban Land Ceiling Act, because the states themselves ceded legislative competence to Parliament for urban land. So this distinction was not kept in mind. That whereas land is something which is outside, completely outside Parliament's scale, just as agriculture is, you will find every single entry, whether taxation or general, are very, very clear in saying agriculture cannot be touched by Parliament. There is only one entry in the concurrent list, entry 41, which says that when you are talking of evacuee property, it will include agricultural land, otherwise no. The exact obverse is true of the mineral wealth of the nation. And despite all that, today, we are now told that a tax on mineral rights includes every kind of tax in and around the mineral, except of course that it cannot be an excise duty or a sales tax. So I don't know what that means, where that leaves us. And secondly, that in any case it's a tax on land. And the moment you say it's a tax on land, you have turned the constitution on its head, because the very entry 50 of that one limitation that the idea is that the mineral wealth of the country cannot be touched by the states because it is so important for the nation. And this is again played up by Justice Nagaratna. Justice Nagaratna tells us how important it is for the nation, how important it is for export earnings, how important it is for the industries that are to be run in the country, etc. And then finally says that therefore I very respectfully dissent. Now this does with the first part. The second part gets even more interesting. The industrial alcohol part. When we come to industrial alcohol, you have entry 52 in list 1, which deals with industries generally. And something like 54 in that it says that when Parliament wants to take over by a declaration a particular industry, it says so. And then the state is denuded of competence completely under the corresponding entry 24 now. So we have to see 52 read with 24. You also have entry 7 which deals with defense industry. Now, we are directly not concerned with these entries, but these entries led to the birth of the Industries Development Regulation Act, just like the MMRDA. And that act was enacted in 1951 immediately. And various industries were taken in. And in 1956, an item 26 was added, which said fermentation industries, taking in industrial alcohol. Now, industrial alcohol is again crucial to the nation's development for two reasons. One, it is a raw material for the chemical industry generally. Second, it gives you ethanol, which is a green fuel. And therefore, it saves foreign exchange. Unlike in the mineral case where you earn foreign exchange. You don't have to import ethanol. And the IDR Act has many restrictive provisions, including the sector's control over these important industries under section 18 capital G. And 18G says that the production, pricing, etc. of all these vital industries can at all times be controlled by the central government. Suppose there's scarcity somewhere. You can directly say, you X will produce and give to Y. You can also directly say, you can give at such and such price. There may be scarcity due to an earthquake. There may be scarcity which is artificial. All these things are dealt with then by the central government because these industries are vital for the nation's development. Now, fermentation industries was added, as I told you, way back in 1956. The entry with which the court was concerned, however, was not these entries. It was entry 8, which said intoxicating liquors. That is to say, production, manufacture, possession, transport, purchase and sale. And it's repeated, of intoxicating liquors. Now, we have three expressions used in the Constitution. You have intoxicating liquors in entry 8. You have in entry 47, which is the directive principle of state policy, intoxicating drinks. And you have in the excise entry, in entry 51 list 2, alcoholic liquor for human consumption. Now, why are there these three different? Do they mean the same thing? Do they mean different things? It's very difficult to say intoxicating liquors and intoxicating drinks mean something different. The essential thing is the verb to intoxicate. So whether it's a liquor or a drink, it must intoxicate in essence. An alcoholic liquor, however, could be wider because it could be a liquid containing alcohol which may not be ingested by a human being at all, which is why it is qualified by for human consumption. That's why entry 51 speaks of for human consumption. So at the end of the day, all three things mean the same thing. However, the learned Chief Justice found otherwise. What the learned Chief Justice and 7 other learned judges found was that we will go by the Abkari Acts. All of them included ethyl alcohol, which was denatured, and in that sense was not potable. That was included within these Abkari Acts. intoxicating liquor therefore had a much wider meaning. And it had the meaning ascribed to it by Balsara's case, which was a 1951 judgment of the Supreme Court, which said it doesn't need to be ingested at all by human beings. It could include industrial alcohol because it only means liquids containing alcohol. Now, Balsara's case was obviously wrongly decided for one very basic reason. Entry 31 in list 2 was unlike entry 8 of list 2 of the Government of India. The predecessor Government of India didn't just speak of intoxicating liquor. It also spoke of narcotic drugs, other narcotics, opium and hemp. And Justice Fazal Ali in 1951 had to construe that entry, 31. Now obviously, if you see intoxicating liquors along with the other 4 entries, what becomes crystal clear is each one of them basically dulls the senses. In each one of them, first, it's a human being who ingests. Second, the common quality is that it dulls the senses. So for that basic reason to say that intoxicating liquor here, cancel the word intoxicating and say all liquids containing alcohol, would, in my respectful submission, be completely wrong. Anyway, Justice Fazal Ali's vision found its way into a 2-judge bench in State of UP versus Synthetics and Chemicals. That got twisted. And finally, 7 learned judges, just as in India Cement, held that Balsara's case was wrongly decided. And ultimately said intoxicating liquor means nothing more or less than potable alcohol. Now the excise entry also tells us a very interesting story, which was not examined by either majority or minority judge. The excise entry 51 specifically said that alcoholic liquors for human consumption you may levy, the states may levy. You may also levy on opium, Indian hemp, narcotic drugs and other narcotics. But you may not levy on medicinal and toilet preparations. The Government of India Act was the exact opposite. It said you may levy also on medicinal and toilet preparations. Why did the Constitution, therefore, make this difference? It obviously made the difference because it wanted to put potable, ingestible alcohol and other narcotics together for taxation and leave it to Parliament to tax things which were not potable and which became, therefore, industry. Now, the Industries Regulation Act, as a matter of fact, has a separate Entry 22, which specifically speaks of drugs. The entire drug industry is in 22, just as the fermentation industry is in 26. And in 29, you have the cosmetic industry. So, medicinal falls under drug. Cosmetic industry is therefore toilet preparation. The scheme was very clear. Despite this scheme, again, the majority said tax entries have their own life. They have nothing to do with general entry. Result, therefore, is we have a very skewed thing now. We have excise duties only on potable alcohol. But so far as the general entry is concerned, it subsumes everything, including industrial alcohol. The reasoning of the court was based on one other thing. It said the entry said intoxicating liquor, that is to say. Now that is to say is not exhaustive according to the majority. It is only illustrative. And when it's illustrative, it would include alcohol which is used as a raw material for another industry. Again, completely wrong according to them. Now, with all this, Justice Nagratna again gave a very vigorous dissent. She made it clear that the line was drawn at potable, non-potable, which is obvious, I think, to anybody. If you just look at the entries carefully, it is obvious that beyond potable you cannot go. But the effect of the majority judgment now is to cut out entry 26 in the IDR Act altogether. It's a very far-reaching effect. So what happens now is, with entry 26 gone, there is no control whatsoever by the center over industrial alcohol. So the result of the 9-judge bench judgment is, each state can deal with industrial alcohol as it thinks fit, first. Second, in the guise of what is called a vend fee, what they really do is to tax now industrial alcohol as the parting of a privilege. Because you remember, there were a number of cases which said, we have potable alcohol, that you have no fundamental right, it's a privilege of the state, and therefore vend fees there are perfectly normal. So two immediate consequences are, you have a skewered taxation to industrial alcohol, and again the nation's economy goes for a sixer, as Justice Nagaratna pointed out. And the second obvious thing is, again, for industrial alcohol, you are now able to levy what is called a vend fee. And that is where synthetics and chemicals, 7 judges was again upset. Now, given these two judgments and given their deleterious effect to the economy, Justice Nagaratna's dissents in both is an appeal now to the brooding spirit not only of the courts but also of Parliament. Because Parliament will want to write this. The only trouble is that there will have to be constitutional amendments that will have to be made. Because entry 49 will have to be subjected now to the same limitations as entry 50. Because that's become a fertile ground for taxation of mining. And likewise, intoxicating liquor will have to be replaced with potable liquor. Both of which can only be done through a very difficult process. You have to have a 2/3 majority in both the houses, followed by ratification of half the states, because it deals with entries in the 7th schedule. But nonetheless, at least one bold and brave judge has shown the way. And I may only end by saying, better sooner than later, either by the courts or by Parliament. Thank you.
That was a great enlightening speech by Sir, lecture indeed for all the fraternity members, for which we've been waiting since last 4 months. Thanks a lot, sir. I request my brother secretary, Sanjeev Jilela, to present the vote of thanks.
Good evening all. On behalf of the Telangana High Court Advocates Association, I deem it a privilege to propose vote of thanks. I thank Honorable Sir Justice Rohinton Fali Nariman Garu, former Judge, Supreme Court of India, for accepting our invitation and addressing the bar on the occasion of visiting our association. I thank Honorable Acting Chief Justice Sujay Pal Garu and Honorable Judges of High Court for the State of Telangana and members of the legal fraternity for attending this occasion. Thank you and all for gracing the occasion. I request all the members to join the high tea in the corridors, please. Thank you very much.